I'll give it just a couple of seconds. All right. Thank you, everybody, for joining us. I'm going to give us a couple of seconds to let people come on. All right. I think we'll go ahead and get started. Thank you, everybody, for joining us today for L2B Aviation's live stream event, Insights from Legal Experts, Considerations when Registering an Aircraft in the United States. L2B Aviation is a network of attorneys around the globe who specialize in aviation. We currently have 45 member firms representing 58 different countries. So we are represented in more than 50% of the globe. Today, we are going to be speaking with Maria Gonzalez with McAfee Taft in Oklahoma City and Andrea Villa with Harper Meyer in Miami. Thank you both for joining us today. Maria is a shareholder with McAfee Taft and focuses her practice on aviation matters, including the documentation of aircraft transactions and aircraft title and registration matters. Her practice involves reviewing FAA records for aircraft, engines, and propellers, and advising clients regarding title issues with the FAA and on matters arising under the Cape Town Convention. Andrea is a partner with Harper Meyer and concentrates her practice on assisting high net worth individuals and companies with international and domestic corporate and business matters with a focus on aircraft and vessel transactions. She counsels foreign and domestic corporate and individual clients on general transactional issues, as well as specific matters relating to acquisition, financing, and leasing of new and pre-owned aircraft, including planning for and implementing tax-efficient structures and more. And both of these amazing women are fluent in both English and Spanish, and we are thrilled to have them as a part of our L2B network. So, considerations when registering an aircraft in the United States. Maria, we have some issues with the FAA, or some updates, not necessarily issues. So why don't we start with you, and you can give us some updates on what's happening with the FAA and what people need to know if they want to register an aircraft in the United States.
Thanks, Tracy. I'm happy to be here. So a couple of things, some recent developments, well, maybe not too recent, but a year and a half-ish or so ago, the Aeronautical Center Counsel's Office stopped issuing opinions, and we would typically go to the Aeronautical Center Counsel's Office and request opinions with regard to trust agreements, a lot of the time, especially involving non-citizen trust agreements. And we would get an opinion from ACC's office that said, yes, this trust meets all the NCT requirements, and you can proceed to register in the name of the owner trustee. Now that the ACC's office has stopped issuing those opinions, they've put that requirement of whether or not the trust meets the NCT policy onto the FAA examiners, which means that the FAA examiner will have to go through the trust and make sure that the trust meets all the requirements under the NCT. Now, why does that affect everybody that are doing filings? Well, that means that it's going to take longer for your documents to get processed. So if you have an international flight scheduled, you'll definitely need to add a couple of extra days to that time frame, because it's going to take a little bit longer for an FAA examiner to go through the trust and do what the Aeronautical Center Counsel's Office used to do and confirm that that trust is the standard form. But other than that, that is one of the biggest issues with the ACC's office, and putting that standard now onto the FAA examiners are the ones that are making those determinations. Another reason we would usually go to the ACC's office are with finance leases, and leases where with purchase options that are the equivalent of conditional sales agreements. We would submit all the leases to the ACC's office and request an opinion. When we would submit the leases to the ACC's office, we would provide the ACC with an analysis of the lease and also provide all the financial information that would normally be omitted and redacted from the FAA filing counterpart. We would get an opinion back saying, yes, this lease is the equivalent of a conditional sale contract that makes registration proper in the name of the lessee. Now, again, because the ACC is not issuing opinions, that changes how things are done. It became a lot of back and forth actually between the aviation attorneys in Oklahoma City and the FAA registry, because our biggest concern was, of course, the redaction of financial information. We didn't want to file leases that have financial information because, of course, our clients don't want any of that to be part of the public record. So it became a back and forth of how can the FAA examiner make a determination of whether or not this purchase option meets the requirements of the Leiter letter, making registration proper in the name of the lessee without the financial information. And how can we achieve the goal of still getting our documents processed, reviewed, and the registration complete without giving away or filing the lease with all the financial information? So what the ACC's office and the FAA registry came up with is basically an affidavit of lessor lessee. The affidavit really puts the lessee and lessor in the position of telling the FAA registry essentially that based on their review of the lease qualifies as a conditional sales contract because of ABC. The affidavit has to set out the reasons why without, of course, divulging the financial information, because that's what we're trying to avoid is divulging that financial information. So the affidavit, while you have to say the reason, you have to craft it in such a way that you're not also giving away or putting into the record all that financial information that we're trying to keep out of the FAA record. So the crafting of these affidavits, we went back and forth for actually several months with the ACC's office and the FAA registry to come up with a form of affidavit. And that affidavit has to be filed with every lease that has a purchase option, and it has to detail the reasons why. And of course, going back to the timing, if you have a lease that's the equivalent of a conditional sale contract, where the lessee will be the registered owner, and if you have an international flight of some kind scheduled, you need to add at least probably 4 or 5 business days to your timeline, because with this type of lease and the affidavit, it's a little bit more complicated of a situation. And the FAA examiner will need to go over the affidavit, go over the lease, and most times they will get their supervisor involved, and the supervisor will go through the affidavit, they will look at the lease, and then they will make a determination. And the agreement that we all decided that we worked out with the ACC's office and the FAA registry was if they had a question or if they needed additional information, they're supposed to send us a letter. Whoever filed the documents will get a letter saying, okay, we have your affidavit, we have your lease, but we're unable to make a determination, or we need additional information. So with these types of filings are a little bit more complicated, and the fact that we aren't able to get those ACC opinions ahead of time complicates it a little bit more, because it used to be that we could get the opinion before closing, we'd file our documents and the opinion at closing, and it was a done deal. There wouldn't be a question as to whether or not the FAA registry would process the documents because they already had the ACC opinion. So it does complicate things a little bit more, and I would highly suggest, if you have this type of arrangement, that you reach out to your counsel early, because it will take a bit of time to craft the affidavit, make sure that it has all the information that it needs, and it doesn't divulge the information that we're trying to redact, especially, of course, the financial information. And also it takes longer. It's going to take longer to get. I actually just filed one about 2 weeks ago, and they had an international flight, and the good thing was their flight was about 2 weeks out from the date of filing, and we actually got the flywire, I want to say, on day 7 or 8 following the closing. So you do have to be cognizant of the timeline, and we were tracking it, and we could see, okay, we filed it on X date. It got to be with an examiner pretty quick because it was priority filing since they had an international flight. But then we saw where it just got placed on hold, essentially, which usually means the FAA examiner that had a question and put it on hold because they had to reach out to their supervisor. And so it stayed on hold probably about 3 or 4 business days. And then about another 2 business days after that, it was it got assigned to a supervisor, and then we got the flywire. So we have to be cognizant of the timeline with these types of filings, because they're not going to be as straightforward as they have been in the past, because of the fact that we don't have those ACC opinions anymore.
Okay, thank you.
Yeah, sure. Happy to discuss. And one other quick note, we were talking about before we got on the live stream, we were talking about the e-filing concept. And as most of you know, the FAA has started allowing e-filing of documents. However, one thing to point out is that when you file documents via email, that doesn't mean that it's directly connected to the FAA mainframe. When you e-file documents, a person at the FAA is charged with looking at that email, and they will print out your filing and then scan that filing into the FAA mainframe. It's a 2-step process, and it's concerning, because you're basically putting a person in charge of printing out and scanning documents into the mainframe versus, we put together our filings and we put all of the documents into the filing bin, and we know that the way that we prepared the documents is the way that they're going to be scanned. With this e-filing process, you don't always have that guarantee, because you're putting that onto an FAA worker who's just sitting there printing documents all day and scanning them into the system. So I think eventually the system will get better. That's what they're working towards. They're working towards eventually getting to the point where the documents that are e-filed are automatically routed into the FAA mainframe. It's not there yet, but that's the route that they're going. That's the route the goal they have to get to eventually.
So back to the affidavit. Do you see that process getting streamlined as you go forward, or is it kind of the way it is going to be going?
Yeah, so I don't know that there's going to be any more streamlining as far as the leases, the affidavits for the leases are concerned. That process was, all the aviation attorneys worked together with the ACC's office and the FAA registry to come up with this form of affidavit. So I think this form of affidavit is as streamlined as it's going to get, and it's going to, unfortunately, that just puts more responsibility on the FAA examiners that are processing thousands of documents a day. So when they get to this type of filing, it will unfortunately just take them more time, because they have to go through the affidavit. They actually have to go through the lease and make sure that it meets the requirements of a CSC, a conditional sale contract. And so that's just going to take more time. Before, we would send all that to the attorneys at the Aeronautical Center Counsel's office, and they would go through it, issue the opinion. And now that responsibility is on the FAA examiner. And of course, that's going to take them more time. When they're having to do this process, this type of filing, it's going to take them more time than just processing a bill of sale and an application, versus with this type of documentation, they have to read the affidavit. They actually have to read the lease and go through the lease. And of course, they're going to have questions. And so in my example, it was on hold for several days, and then it got assigned to an examiner, a supervisor, and then the supervisor ultimately processed the documents and issued the flywire.
Okay. Thank you. That's good information. Andrea, there's been a lot of talk recently about the Corporate Transparency Act coming up. So what do we need to know about that and registering aircraft in the United States?
Sure. Thanks, Tracy. And that was really great, Maria. I will back that up. We have experienced the same delays, and it has kind of been mayhem waiting for those flywires. So it is true. I think everything Maria says really highlights how important it is to have good advisors in Oklahoma helping you with your filings, because it's very specific and it's taking a little bit longer. So planning for it is great. But for the other regulatory change that we've been talking to our clients about, it's the Corporate Transparency Act that goes into effect on January 1st, 2024. And the Corporate Transparency Act, or CTA, applies to a U.S. entity that's created by filing a document with the Secretary of State or its equivalent So that would include all US corporations, LLCs, statutory trusts, and business trusts. This also includes foreign companies that are registered to do business in the United States. So, of course, these are very popular entities used in aircraft transactions. And for example, in our firm, we think probably around 80% or more of the entities used in US registered aircraft transactions will involve one of these entities, right? So our goal is to determine whether these entities used in the aircraft transaction will have reporting obligations or whether they will meet one of the 23 exemptions. So what CTA is going to require is that the company, its beneficial owners, and its controlling persons file an online report with the U.S. Department of Treasury's Financial Crimes Enforcement Network, so FinCEN. And the information that's actually required in the report isn't complicated, right? But because this is a new regulatory requirement and so many people are still unaware of CTA, I think right now the most important thing is going to be education and communication with clients, right? And this is especially because the fines for non-compliance are pretty high, and it could even result in criminal penalties. I think the fines right now are $500 per day up to $10,000. And it could also include 2 years of jail time. So we are talking about some serious penalties. And this informational report that's required is required from the company, the beneficial owners, and the controlling persons. And they're just going to have to provide FinCEN certain information, right? And this information will include information about the company, copies of the passports and or government issued IDs for the beneficial owners or controlling persons, and their addresses. And this is obviously something that not a lot of clients are used to, right? So it's going to take them by surprise, and it's going to take some long and educational conversations to make sure that we're complying. And I think everyone's initial question is always, when is this all happening? When do I have to comply, right? And then the answer is going to be, it depends on when the company is formed. So for existing companies, so companies that were created on or before January 1st, not on. So before January 1st, 2024, they will have until January 1st, 2025 to comply. So I know that this probably seems like a long time, but it looks like right now the Corporate Transparency Act is going to affect about 32 million companies. So that's going to be a lot of compliance. And still we are seeing that a lot of people are unaware about it, right? So spreading the word is really, really important. And then for entities that are created after January 1st, 2024, they will have 30 to 90 days from formation. The exact date is TBD because there's a lot of unknowns still, but it will be for 30 to 90 days from formation to file that initial information report, right? And in that report, these companies that are formed after January 1st will also have to include information about the company applicants. So these people are the people who helped you file and create the entity, right? So that could be me, for example, if I helped a client create an LLC, or a paralegal or another attorney in our office. And so that's a lot of work. We help a lot of clients create entities. So there is some controversy, of course, revolving around the CTA and how burdensome or not it's going to be. But what we're mainly focused on right now is getting the clients informed. I think probably one of the more difficult things that we're going to see is like with respect to CTA compliance in general, is that any information that is provided on this informational filing, if it has to be updated because some information changes, the company will have 30 days from that change to amend the filing. And this sounds easy, but if you think about it, it's probably more complicated than you think, right? So if, let's say, the CEO or the CFO of a company's address changes, somebody has to let somebody know, right? And fix and amend this filing. And a lot of the time, CEOs and CFOs don't really have it in their head to notify someone proactively that they've changed an address unless they've been prompted, right? But this 30-day timeline is pretty short. They're going to have to notify someone, or they're going to have to go in there on the portal to update this information. So I think that's probably going to be one of the tougher parts for compliance. Another thing that we are potentially preparing for is, making sure that any information that we file, for example, in FAA documents, matches the information that we're going to file for CTA. So, for example, we'd want to avoid a situation where we have an aircraft registration application that lists the company and its address, but then that same company lists a different address for CTA, right? Those types of inconsistencies we definitely want to avoid. We also want to have the conversation with clients. Some of them may not feel comfortable sharing some of this information. So we have until January to kind of restructure if they don't want to share this type of information. I think our main focus right now is determining whether the entities used in our aircraft structures are subject to CTA and what their reporting requirements are going to be. As I mentioned earlier, there are 23 exemptions, and most of these exemptions are going to apply to bigger companies, so publicly traded companies, banks, companies with, for example, 20 or more employees that have offices in the US and that have reported more than $5 million of US income in their prior tax return. These types of entities will be exempt from filing, right? But all of the other ones, if they're subject to CTA, I think that conversation should be start to happen right now, because we're going to have to start compiling these documents, right? We're going to have to start determining who the beneficial owners are, who constitutes as a controlling individual, what type of information do we have? Do we have their passports? Do we have updated passports? What are their addresses? And what process are we all going to have in place? For example, if we're helping a client with these filings, we need to make sure that the client knows, hey, I need to notify my attorney if I change my address, or I need to notify my attorney if we have a new director or a new officer, right? And sometimes these changes happen very frequently, right? And sometimes these companies are formed by owner pilots, right? And they don't even have a registered agent who's knocking on their door, reminding them, hey, you may have to comply with CTA. So I think it's really important that we all, get the word out to make sure that we're ready, because January 1st is fast approaching. I think another probably important thing to note is, in order to make this filing, the company is going to have a tax ID. So that's another question, right? Making sure that all of these companies, especially if we're talking about a foreign company that's qualified to do business here, or maybe, you may have a situation where you have a US LLC, but that's owned by a foreigner and doesn't really have US income. So it didn't really obtain an EIN to begin with. It didn't have a tax ID. But now for CTA compliance, we need to make sure that they have this tax ID so that they're able to make these filings. So I think with these types of conversations, we're hoping to get everyone informed and on the same page so that we can comply with these requirements.
And Andrea, this just really quick, I hate to interrupt. When you were talking about the registration application and the address, a lot of our clients tend to put the address of like their flight department or the address of the people that are actually going to do something, because the main piece of mail the FAA sends is the reminder to renew your registration. And so usually our clients will put on their flight department or somebody that will actually respond and take care of the renewal. So what's going to happen now? So can they still do that or do a care of and still be in compliance with CTA? What is your advice on that?
Right. And that's actually, so NBAA also participated in the comments portion of this rulemaking, because a lot of us have many questions.
Mm-hmm.
A lot of this is still up in the air. Even the portal itself isn't really set up yet, and January 1st is tomorrow, basically. So
yeah,
a lot of unknowns. But for your question specifically, what we've been talking about internally is we just want to avoid an appearance of an inconsistency, just because these penalties are pretty high. We're talking about $10,000, right? So, like you said, I think the best way would be using the care of, so that there's no question that we are saying that the company's address is one here, but we're saying that the company's address in CTA is something else. And the same thing goes for the beneficial owners, right? Sometimes in our trust agreements or other lease documents, we write in their address, but it's more of a mailing address or their office address. So we just think that we're going to have to start paying a little closer attention to how exactly we write it. Maybe before we used to skip over the care of and actually include it here, just so that optically it doesn't raise any questions, right?
Right. That makes a lot of sense. Yes, you're right. In the trust agreement, there's the contact section, and a lot of times it's not really the actual beneficiary's address. It's whoever's getting the mail and actually actioning the whatever needs to be done, because the owner trustees also send the beneficiaries requests for information to comply with the NCT policies and such. But that's a great point, that we're really going to have to focus on the care of address, when we're doing the addresses going forward.
Yeah, exactly. I think that that's going to be important, because we don't know how they're going to determine whether you lied about an address, right? And we don't want to give them a reason to see our registration and say, hey, you're holding yourself out to having this address, but you're only reporting this one, so you should have reported this address in your CTA filing.
Right. Yeah.
That's some really good information. Do we know when the portal's going to be open? January 1?
So, yeah.
Midnight?
They're really keeping us on our toes and waiting for the last minute. We're hoping soon, right? Because I'm sure there's going to be glitches. And I'm sure that it's going to be a learning curve to try to get everyone registered. The good news, I will say, for example, for us, Maria, if you're also helping with creating companies, there is going to be, I forget the name. I think they're calling it like a FinCEN identifier number, where, for example, I would just write in my information once, and then it would give me a number. And I could just use that number for every company that we've helped form, right? And the same applies, there are directors that are directors of many companies. So they don't want to have to go in there and type the same information over and over again, send their passport over and over again. So it looks like that was one of the things that everybody was very adamant about in the comments, that this is burdensome to begin with. Let's try to make this easier. The FinCEN number should help us expedite these filings.
That's great. All right, thank you. Okay, so now we'll go to the issue of the export issue that has kind of been a topic for maybe 6 months, a year. So there are a lot of details on this, and we're going to stay high level on what you should know. But it's definitely an issue, particularly for people registering in trust or flying aircraft internationally regularly. So, Maria, why don't you give us an update on what you need to know about exports?
For sure. And like Tracy said, we're going to do a more of a high level general discussion. But for sure, I think the biggest point I want to make to everyone else that's listening to us is hire a customs broker. Customs broker knows all the ins and outs of any customs filing that you need to make. So that's definitely step one with dealing in when you're in a situation where you have a U.S. registered aircraft, but perhaps you're going to base it in another country, or perhaps you're going to be outside of the U.S. for 6 months or a year or longer. So definitely hire a customs broker, because they will be able to give you direction as to what types of filings need to be made. I think recently the biggest kind of media buzz we've seen is, do you have an EEI? Do you have the electronic export information number? Did you do that filing? This was probably a year ago when all of this came to light through the Wright brothers case and everything that happened during that investigation that they did about a year and a half ago now. And so they are cracking down on these filings and whether or not you made the filing when you left, and do you have your EEI? So if you have a U.S. registered aircraft, even if it was registered to an owner trustee, when you left the U.S., did you file that EEI and do that filing? Because they're starting to crack down on that. And Andrea will provide some colorful examples here shortly. But that's kind of just a very high level. You hire a customs broker. If you're going to base your aircraft outside of the U.S., make sure you're doing the necessary filings. And the same when coming back in. When you're coming back into the U.S., you also need to do the customs filings for that import.
Yeah, definitely. And I think one of the important or key points to take home from this is trying to get ahead of the issue, right? So at the very beginning of a transaction, it's important for everyone, seller, buyers, brokers, to all work together to find out whether there's going to be a requirement for a filing, or whether maybe the aircraft that we're talking about should have filed and didn't, right? I think there's probably two big misconceptions when it comes to exports. And the first one mainly involves clients who are coming to the US, purchasing a US registered aircraft, and really have the intention of exporting this aircraft, basing it in another country, even deregistering it. And they confuse the FAA export requirements with customs export requirements, right? So they say, hey, I got permission from the FAA to deregister, and I got an export C of A. I completed my export requirements, right? What they don't realize is they also had to make that EEI filing, that customs export filing. So I think that's one of the big ones. And then probably the second one that came out from over this year and a half that we've all started to hear about, it is the hot topic, is the buyers that come into the US, buy a US registered aircraft, keep the US tail number, but want to base and hangar the aircraft in another country, right? So most of these people are under the impression that because they're keeping the US tail, there was no requirement to file an export. And that's where we sort of found ourselves a year and a half ago, to where we were in constant communication with the government, trying to find a way to rectify a lot of these aircraft that were purchased, really had been based abroad and never made the filing. So that's where the retroactive export code came out of. So I think moving forward with aircraft transactions, it's important to talk to everyone involved to find out who had, if there were any export or import requirements, and try to get ahead of them as early as we can, right? If
Mhm.
you are, for example, a seller and you had based your aircraft abroad and you find yourself in a place where maybe right now in this webinar, you find out, that's me. I never filed it. What can I do? Get in touch with one of us as soon as possible and we'll help you, right?
Mhm.
Before you are stuck in a situation where, and we've had plenty of these, where sellers had based their aircraft abroad, never made an aircraft filing, and it comes time to sell their aircraft and they're very excited. They bring it to the US, they're ready for the pre-buy, and then the buyer asks them, hey, can you send me your ITIN, that number that shows that you exported this aircraft? And they're just deer in the headlights, freaking out. What do we do? How do we fix this, right? So in that situation, it could become a little more complicated because that aircraft already came into the United States, right? Depending on when exactly they purchased it, they may be eligible for a retroactive export. So we could potentially help them with one of those. If they're not eligible, and of course we're the customs broker, and if they're not eligible for that one, we could talk about maybe filing a voluntary disclosure to get that filed. But then we also have the problem, hey, you came into the US already, so you should have imported on the way
Right.
in, and you didn't. So in those situations, I think with the year and a half we've learned a lot and we've gotten pretty good at certain things. So those clients that came in without importing that should have, we have finally found a solution for them. We have a customs broker that's fantastic that is able to help you make a voluntary disclosure of the import and help you clear. At the beginning, like maybe a year ago, when we had situations like this, we had aircraft stuck without clearance for over a month, right? So imagine being mid-transaction and this seller now is stuck not being able to sell. The buyer is, hey, I'm out. I don't want to buy this anymore. And we, our hands are tied. We're kind of waiting for customs to clear it. So that is something that at least in this year and a half we have mastered. We are able to clear them on their way in fairly quickly. Of course, the faster we find out about it, the more we can do. And then we also have buyers, for example, that are requiring or requesting that we put into our purchase agreement certain provisions, right? So if you're a buyer and you've seen that the aircraft that you're purchasing had frequent flights to Ecuador, for example, or was parked in Ecuador for long periods of time, you may be under the impression, hey, maybe they should have exported. Let me make it a condition precedent to closing for them to show me that they filed the proper export and that they filed the proper import for the pre-buy. And so this could catch a seller by surprise if they're not prepared. And same goes for buyers, right? If a seller knows that this potential buyer, it has a base in Brazil, for example, and may base this aircraft that they're buying from you in Brazil, we may want to add some sort of covenant or indemnity provision in our purchase agreement that says, hey, buyer, as soon as we're done with closing, you certify that you will comply with all export regulations and filings required to base your aircraft abroad, and you will indemnify us for any costs associated with this, right? So there's a lot of things we can do in the purchase agreement to protect both sides from it. And there's also a lot of things we could do for clients that maybe find themselves in a position of not having exported when they should have, right? Or if they need help exporting and can do it in a timely manner, we can definitely put them in contact with great and efficient customs brokers and get all the filings in place. Of course, it goes without saying that all of this requires planning, right? So we have to add time to our transaction schedule for this, right? We have to make sure that we all talk about this early enough to where something like an export is not delaying our closing transaction.
That seems to be the common theme of our presentation today, just timing and getting everything set out at the beginning, because things are just taking a little bit longer than they have in the past, for sure.
Yeah, I think the timing and communicating, right? Saying absolutely everything to your advisors, right? To your brokers, to everyone, because sometimes these transactions work in silos and the broker wants to get the aircraft in here as soon as possible because the slot is on such and such date. But then we're saying, hey, we have to make sure we import before you get it in. So all of these have to work hand in hand with each other. So the more we talk about things together and the earlier we talk about them, I think will help us have a seamless transaction for sure.
Well, and I completely agree with you on that. It really, if a seller doesn't want to disclose this information because, oh, I didn't do it, I think at the end of the day, if the longer they wait to disclose it, the worse it's going to be. So I think you're absolutely right that all of this needs to be disclosed at the beginning. And if seller knows, oh, crap, I didn't do this, and, what can we do to fix it? If they tried to hide that fact or not disclose it, I think it's just going to be worse in the end. So I think the one piece of advice that I think everyone should take away from this presentation is, like you were saying, Andrea, disclose everything up front, communicate. And if there is an issue with the customs filings, it's better to get that out at the outset of the transaction and deal with it versus waiting until everyone's ready to go. It's 2 days before closing and, oh, now we can't close.
Exactly. The good thing there is that we have seen, for example, some trust companies set up in their, like, for example, if a buyer is going to purchase an aircraft and place it in trust, they have now these questionnaires that are buyer questionnaires that are asking the key questions. Hey, where was this aircraft based? If based abroad, do you have an ITIN? If same thing for seller, if you are selling an aircraft that's coming out of trust, we have seen some trust companies, for example, TVPX now has a seller due diligence checklist that says, hey, where was this aircraft based? Do you have an ITIN? So before where folks maybe thought, hey, maybe I'll hide it. I won't say anything. I'll stay very quiet and make sure, hope it goes away. It's getting harder and harder. And same thing with financing, right? The financing institutions are asking their borrowers, hey, show me your ITIN. I know you guys are based in Costa Rica. So it's something that we're seeing buyers question, sellers question, trust companies question. So it may come up if you're dealing with an aircraft that spends a lot of time abroad.
Right. Yeah, I think you're absolutely right. Especially the trust companies are getting are asking all the right questions now. I think they've been hit so hard over the last 5 years with everything that has changed, everything they've gone through. I think they are a great source of asking all the right questions because, unfortunately, they've been hit the hardest over the last 5 years with all the implementation, starting with NCT, following up with the custom. I mean, they've had to deal with a lot over the last several years.
Yeah, definitely.
It even goes back, I almost think, 10 years, right? I mean, the original issues with trust hit in 2013. So, I mean, we're looking at 10 years since we first started all that.
But that's true. In 2003, that's when the ACC's office was trying to do away with the trust structure completely. And so the trust companies really have been hit hard with new requirements and different requirements from all points, from not only from the FAA registry, but from the ACC's office, now from a customs perspective. So they are having to be a lot more diligent with all these questions.
For sure.
Definitely.
Yeah. Well, ladies, this was really fantastic. Thank you so much for your time here. We don't really have any questions, so I think unless you guys have other comments, this was really great.
Oh, thank you so much for having us. I think we hopefully provided some good information. And like Andrea was saying, please reach out to us, and we're happy to help with these issues and questions. And again, reach out to us early so that we can ensure that we can get the transaction done in a timely manner.
Yeah, and to your point, Maria, and Andrea, things taking longer. Some of that is an increase in regulations. Some of that is restructuring of the FAA. It's just changes that they do take longer, and you have to be proactive and diligent, but to do your due diligence, which is challenging sometimes in an industry that wants to close yesterday.
Right.
Exactly. That's why I think it's important we all work together, right?
Right.
Opposing counsel on the other side will understand if maybe we're asking a little too many questions about who the beneficial owner is and where they're going to base the aircraft. Now they might know why.
Yeah,
right.
For sure.
Yeah.
So to that end, thank you everybody in the audience for joining us. If you have any questions, would like to learn more about L2B, you can go to our website. Both Maria and Andrea are listed on our website, and it's l2baviation.com. And we've enjoyed having you, and we thank you again for joining us today.
Thank you.
Thank you, ladies.
Bye-bye.
Bye.